good afternoon. Let me welcome you all back to our next special 100th anniversary program. And let me begin by just saying a word or two about how these 100th anniversary events all came to be. As you've seen, there was a committee devoted to putting together the special programming for this milestone in the ALI's history. And one of the subcommittees was the subcommittee on the ALI's history. And Ed Cooper from the University of Michigan and I happen to be the co-chairs of that subcommittee. What you see before you, this, if you don't have it yet, it's available. This book was a long time in the coming. We had to think about what could we do to commemorate the ALI's history? And if we were going to have a book, what ought to be in that book? You don't want a whole book full of, and then there was the next annual meeting, and then there was the next annual meeting. Nobody would get too much out of that. But on the other hand, you want a book that just reviews all of the work product? Not really necessarily either. So we came up with what you now see, a table of contents that covers the critical parts of this book, the founding and the development of an institution like this, and it's a little bit hard because there really aren't any other institutions quite like this in the United States. Something that did look at our work product, both how it came about, whether it was controversial, whether it was influential, what exactly were we doing. So you see the restatements, the codes, the principles, and then, in a sense, how does it all matter? And none of this could ever have happened if it had not been for the generous willingness of both Professors Gordon and Professor Gold to lead the way, to shepherd this book to conclusion, to work with all of the authors themselves to participate. So we're so lucky to have them and some of the participants here with us this afternoon. Professor Gordon himself is a preeminent legal historian. He's a great scholar, a great teacher, and he is somebody who has been at all sorts of places. It says he received his BA from Harvard, JD from Harvard, taught previously at Stanford, taught at Yale, taught at Buffalo, visited at Harvard, Oxford, etc., has done so many different things. And he was the first person I called, and I was so happy when he returned my phone call. I wasn't sure what exactly my reception was going to be, but it was very, very positive. And he was joined by Professor Andrew Gold, who's a professor of law at Brooklyn Law School, who has a wide range of research interests, but took up this project as well. So I think I'll turn it over to the two of you to introduce the project further, and we look forward to what everyone has to say. That's it. See, it's like a little face.
I see. Okay, it works. So, welcome everybody, and I'll just say a few words to introduce this project and some of my co-authors on the project. As Judge Wood said, the inception of this project for me came when a call came out of the blue from Judge Wood asking if I thought it was feasible to do a Centennial History of the ALI, and I thought, well, I'm not sure. Going to be a big, kind of complicated undertaking, but let me see. Let me ask some people and see what they think. So I emailed about 100 people who knew something about the legal history of the 20th century, and said, what do you think? Would it be feasible to do a history of the ALI, and what kind of a thing should it be? And most of them emailed back and they said, yeah, it sounds interesting, that sounds feasible. Pretty early on, rejected the idea of trying to commission a single author to do the whole thing, because that would have to be somebody who was capable of handling like a Pentagon-sized warehouse of paper, and would have to be expert in 40 or 50 different fields of law that really didn't seem like a feasible undertaking. So we thought maybe a multi-author volume. Then sent out a bunch of other emails to plausible people who were interested in the subject to ask if they would be an advisory committee for the volume. Almost everybody agreed. Some of them, I was then looking around for a co-editor because I didn't want to take on the whole thing myself, and some of them recommended Andrew Gold, whom I had not known, but this was a very fortunate discovery. I've been very lucky in my collaborator. Andrew has done more than his share of everything, the editorial work, and is particularly responsible for shepherding the volume through the press. And we've become friends as well as collaborators, and a happy association it has been. One of the things that we were quite sure was that we didn't want to produce a kind of a spiritless chronicle of meetings and events. That the emphasis should be on an intellectual history of the substance of the major projects of the ALI, and then accompanied by an institutional history of the institutional developments that made the whole enterprise possible. And and then we had to sort of select among projects, and selection was wanted some of the major private law fields which were the subject of the restatements, like torts, contracts, property, and so forth. I think the one we left out was agency. The major codes, Uniform Commercial Code and the Model Penal Code, and then some of the major principles projects, the family dissolution, corporate governance, and aggregate litigation, and finally some synthetic chapters cutting across the various fields. Institutional history, which Deborah DeMott is going to talk about a bit. The context, the social context and political context in which the ALS projects evolved, which Ted White is going to talk about in today's panel, and finally the restatement projects as a form of legal theory. The ALI's projects have been an important contributor to the jurisprudence of American law in the 20th and beginning of the 21st century, and we wanted people who would address those issues. So this is and what we discovered, of course, is an amazingly rich treasure trove of history of law in the American law, in primarily the 20th century in the last 100 years. The ALI's products are, of course, group products. They're products of collective thought and deliberation, but they are anything but bland products. It partly has to do with the fact that the ALI selected as its reporters, has always selected its reporters, people of kind of vigorous, independent intellect, and most of the great names of the American legal thought in the 20th century are represented in its projects. People like Samuel Williston, Arthur Corbin, Carl Llewellyn, Herbert Wexler, William Prosser, a remarkable list of giants of the law. The group products have also been rescued from blandness by the fact that over time, as Ted in particular will say more about, the projects become for various reasons more and more the subjects of controversy, sometimes even intense controversy. one of the things that this results in is the hiving off of areas of particular innovation and controversy into principles projects. So with that, I think I'm going to pass the baton here to my exceedingly able companion and collaborator, Andrew Gold.
Thank you. Is my mic working? Okay, so first off, I just want to say that it's been a great honor to work on this project for the ALI, and also to get a chance to work with Bob on it. Just intellectually fascinating study of the American Law Institute, of the restatements, of the principles projects, and of course also the code projects. I just wanted to give a very brief overview of some themes that I think are important in the book. Many of them on the theory side have to do with what it is to restate, and in very different senses. One of the key issues that shows up early in the book is the question of why you would have a restatement at all, what the purpose of a restatement is. And we see an early theme that it was to address complexity and uncertainty in the law. But of course, there are different senses of complexity. One worry just has to do with the fact that you have 50 states in the Union. You have multiple legal systems here with multiple common laws, in a sense. And that creates a type of complexity. But there are other types of complexity that matter as well. You have the issue of the often complex fact patterns that are tied to case outcomes. You have a proliferation of case law itself. You have different language sometimes used for similar or even identical concepts. And you may also have what Henry Smith and I discuss in our chapter, which is a problem of interdependent parts of the law, which can be complex as well. Another theme that shows up, again, about what it is to restate, is a comparative point. So there's a question, is a restatement really like a code? In some respects it is, but in some very important respects, like non-bindingness, it is not. Or is a restatement in some ways more like a treatise? And as Deborah DeMott will mention, there were some very important questions about linkages between restatements and treatises in the early years. Or, as John Goldberg suggests, is there a sense in which restating the law can be a little bit like what an appellate court does when it reconstructs the law? These are, in some cases, very different ways of thinking about what it is to restate. You also get a question of what material is being restated. Majority rules, in some cases perhaps minority rules. There's a question what it means to restate when you have gaps in the law, or what it means to restate if a restatement is anticipating the future path of the law, for example. And again, these raise different possibilities. Of course, the law changes, and in light of that, restatements change as well. But they change in a different way from the typical incrementalism of the common law. We get restatements first, second, third, fourth, but sporadically. And there are multiple reasons why restatements might change. So, of course, the law changes, but also society and social norms change. And, of course, the membership of the ALI and its reporters change as well. And that's another theme we see in the chapters. I mentioned that restatements are non-binding. Another interesting set of questions relates to the effects of restatements. So Frederick Schauer in his chapter suggests that there is a certain sense in which restatements, some of the time, for some provisions, can actually be law. And I think some of the arguments there may prove to be provocative, but he suggests that while restatements are generally understood to be persuasive authority, they may actually be law in certain settings. And that also raises some very interesting questions. Whether or not restatements ever qualify as law, there's also a set of questions about their impact more generally. Rick Brooks here on the panel suggests that restatements can actually be understood to be canonical. And that raises questions about how restatements are relied upon and also how they're interpreted. Lastly, it may be that there are some things that are not well suited for restating. There's a reason why principal projects exist as well, and likewise why some things are codified, and we have chapters on those too. And with that, I'll leave it there for our panelists.
So let's start with Ted White.
Thanks. I'm going to make 2 points, larger points. One a kind of intellectual history jurisprudence point, and the second an institutional history point. The first has to do with something that's been mentioned already and will be mentioned more, and that's why when the framers of the ALI got together and announced their intention of commissioning restatements of common law subjects, why they identified as motivations for doing this the labels uncertainty and complexity. What did those, I was trying to imagine, in Ken Abraham's and my chapter, we were trying to imagine the cultural setting in which those terms were used and how they might have been understood to contemporary actors. One has to remember the ALI starts in 1923, and the idea of doing it is earlier than that. So we're talking about the very beginning of the second decade of the 20th century. Now, need to imagine these are people, the framers of the ALI are most of them in mid, maybe even late career. So their educational experience would have been in the 19th century. What sort of understanding of the sources of law might they have had such that they would all of a sudden conclude that in the dawning of the 1920s, the common law was, quote, uncertain. We may be accustomed to think that because of the influence of Langdell at Harvard and the development of the case method system, that most people's educational experience from 1870 on would have been rather comparable to maybe even contemporary experience where one is teasing out legal doctrine in the context of fact patterns and trying to train students and lawyers to understand how dependent the doctrines are on their application to the particular fact patterns. So there's this kind of interplay of facts and doctrine. That wasn't quite the approach in the late 19th century. Langdell didn't teach his students to unravel the fact patterns and then conclude in the end that offer and acceptance was utterly dependent on the setting, the factual setting of the case in which that doctrine was raised. Rather, he's training students to understand that cases with facts are embodiments of principles. So what you do is you take the particular case and say it stands for a principle. So you're really searching for authoritative propositions of common law, using the case as an emblematic of those, rather than suggesting that the propositions are utterly dependent on their factual application. Now, it's true that certain Socratic teachers in the legal academy in the late 19th and early 20th century modified Langdell's approach and became more interested in the interplay I've just described. But it is still the case, Ken and I are arguing, it is still the case that by the dawning of the 1920s, many people in the legal profession are still thinking in terms of the law being a collection of fundamental principles. The common law subjects being aggregates of those various principles. And so what uncertainty comes to mean, we argue, for this generation, is uncertainty about what the principles actually are. That is, when we're talking about common law subjects and we're talking about doctrines governing those subjects, what exactly are those doctrines, and can we understand them to be largely of universal application? If not, we have a problem, because then how is How are lawyers going to give guidance to their clients? How are litigants going to understand what their actions are governed by? So it's not just that things may be uncertain, it's that uncertainty is unsettling. In the same manner, complexity is unsettling. And to understand that, we need to understand that there isn't a very strong history of the reporting of judicial decisions throughout the 19th century. In the years of the Marshall Court, there's almost no reportage of state court decisions. There's a few entrepreneurial reporters that emerged in New York, Massachusetts, and Pennsylvania. And being a reporter is itself an entrepreneurial phenomenon. You're trying to make money on the subject, so not everybody wants to do it. And it's only really in the last decades of the 19th century that reportage becomes ubiquitous, and the West Publishing Company emerges, and the West Publishing Company becomes a codifier of state decisions, and we get the division of state courts into various regional areas, and we get the alternative citations. This results in a proliferation of decisions. It is now possible to view state by state, federal court by federal court, how the law is emerging. And it turns out it's emerging in an unsystematic way, and it is it's difficult for lawyers and judges and legal academics to total it up. And that again is a problem. If the law is complex, then how does one reduce it to relatively simple messages so that, again, clients can understand what they're supposed to do, lawyers can understand what they're supposed to advise, courts can have a sense of what the controlling principles in their jurisdiction are. So the ALI thinks this is worrisome, and we're arguing that it's worrisome in a very particularistic early 20th century context. And the reason, and that context is controlling, we argue, for the choice of the restatement format. Imagine if you're worried about uncertainty and complexity, that your response is to commission a series of black letter volumes without commentary, reducing common law to sort of bare bones, without much guidance as to what you do if the bare bones don't precisely work in a particular case. Now that result, the commissioning of restatement volumes that amounted to collections of black letter principles with very little commentary, very little caveats, very little application of the black letter, that's partly accidental because the original intention of the framers of the restatements was that they would be accompanied by treatises. The idea is that you assign reporters, mainly from the academic profession, that are already experts in their common law subject matter areas. So Boland in torts and Williston in contracts and Meacham in agency and the understanding is these people know the field intimately, and so it's going to be relatively easy for them to collect the black letter and set it forth. But they're also going to produce accompanying treatises which will give the details, give the case applications, and perhaps investigate further some areas that are uncertain. But that doesn't materialize. And it doesn't materialize really for financial reasons. The ALI has a grant and really is dependent for its initial existence on a fairly substantial grant from the Carnegie Foundation. But it doesn't have an infinite amount of money. And when it comes down to the decision to whether you're going to publish a treatise, especially a treatise that is commissioned for the event, not an existing treatise, but one that is designed to accompany a restatement, that turns out to be lengthy and potentially expensive, And at some point, the people making decisions are unconvinced that the membership of the ALI will want to buy such treatises. So the decision is made to omit the treatises and proceed with the black letter. Now, bear in mind that when the restatements collectively came out in the 1930s, largely in early 1930s and late 1930s, I don't think either the reporters or the advisors or the framers anticipated that there would be a wave of criticism, mainly from legal academics who were by that time enthused with the realist movement and inclined to reject the idea that the law was a series of foundational propositions that doesn't change with time or dependent on factual circumstances. The ALI didn't anticipate the wave of extremely critical reviews in major law journals, basically in some instances coming close to saying this was a totally worthless project. I mean, what you've produced is an illusion. And so the ALI decides to do some stock taking, and the result is a decision made by a committee chaired by Learned Hand to commission a second series of restatements. And notable in the transition from the first to second restatements is a much greater emphasis on commentary, on suggesting to the readers that there are going to be areas that remain open and indeed in which the reporters are not taking positions. The idea then that what is being offered in the restatement as doctrinal propositions are in some sense tentative and subject to application over time. That's a quite different jurisprudential posture from the posture animating the first restatements, and I think it reflects how many people by the time of the second restatements have imbued the attitudes of realism and different conceptions of what the law is and where it comes from. So that's a brief sketch of the jurisprudential history. I now want to talk a little bit about and move the calendar forward a little bit about the institutional changes that are going on. And let me start by telling a couple of stories of incidents involving William Prosser, who was, after Boland died and was temporarily succeeded by Warren Seavey, who was then taking over as the restatement of agency, and so he needed somebody else to complete the project. Prosser had written his very influential Torts Treatise, first edition, in 1941, and was writing widely in the field and was a natural choice to be the reporter for the second restatement. Prosser was a authoritarian figure. He did not brook opposition well. At one point, he resigned from the deanship at Berkeley because it was indicated that he needed to retire as an administrator at a certain age, and he resented that. And so he retired early to spite those who had made the rule. He also resigned as reporter for the Torts Restatement, and I'll tell that story in a minute. But this is somebody who's very self-confident and also very hardworking, and so Prosser is one of Prosser's projects in the 1960s is the emergence of strict liability in tort. And he writes two very influential articles, one called The Assault on the Citadel and the other The Fall of the Citadel, and they're written over a very short span of time, maybe 2 or 3 years. And the cumulative point of the articles is, out of nowhere, this idea of strict liability in tort emerges. The courts are beginning to pick it up, and now, lo and behold, it's triumphed, particularly in products liability cases. So Prosser in the second restatement has a section on products liability, very famous section, sections 402A and 402B of the second restatement, basically codifying what he takes to be now the principles of products liability in tort. He presents that to the membership, to the council and to the membership. Now, if you look closely, as Ken Abraham has done, if you look closely at those two articles, they're very thin on case citation. There wasn't a whole lot of assaults going on, and it's very unclear that the citadel had fallen. But Prosser had a gift for language and a gift for argument, and he apparently pulled it off, so much so that he creates these sections based on his research, if you will, and what he concludes about a product's liability, and the membership, the council, and then the membership just sits back and says, go for it. People don't get up and say, well, wait a minute, you know, in my jurisdiction, I don't see any of this. So this is about 1965 when Prosser presents the tentative draft, which is subsequently approved. About 5 years later, there's a section on nuisance, and Prosser presents a tentative draft to the membership. Now, in those 5 years, 65 to 70, the membership of the ALI has undergone some dramatic changes. And the changes center largely around the fact that law firms are getting sufficiently large that partnership competition has become relatively severe. And a lot of the firms that are growing and hiring junior associates to grow, need to find something for their people that are not making partners to do. And one of the things they find is house counsel. They have by this time developed ongoing relationships with some major clients, and they basically farm their disappointed partner candidates out to the clients as house counsel. Very shortly, the issue of whether the ALI shall elect house counsel emerges, and there's considerable debate about it. And the ALI temporarily resolves it by saying, well, yes, we're prepared to elect some people that are not in law firms, but are house counsel for various corporate clients, provided that they, quote, leave their clients at the door. The expectation being that you know, you come to an ALI meeting and we're all about principles of the law, and we're not all about special interests or other kinds of debate of that sort. Well, in short, that doesn't really work. The people who join the ALI, not just people who are house counsel, but other people taking on increasingly specialized practices, begin to see themselves as, I don't want to put it crudely to say representing special interests, but having a consistent client point of view that they want to air. And so when Prosser proposes his nuisance section, we get on the one hand people thinking that, yes, tort law needs to develop in terms of expanding its coverage to address not just private nuisances, but public nuisances, becoming a kind of a surrogate for environmental protection. And on the other side of the coin, people think that tort law ought to get out of the business and leave it to regulation, leave it to environmental protection. So when Prosser proposes what really is a kind of moderate expansion of the nuisance doctrine, he gets very virulent opposition from both sides, including a major attack by two Harvard law professors on the doctrine. And the membership votes to recommission the project. Basically, go back, Professor Dean Prosser, go back and rethink this and come forward with something else. And Prosser's response is say, go to hell. I'm resigning. Well, that's pretty much of a sea change in the atmosphere of the ALI. I'm not suggesting that ALI meetings today are filled with this kind of hounding of reporters by the membership, but it is certainly a different institution in a very dramatic change. So I think the challenge, the 21st century challenge institutionally for the ALI, Ken and I go on and talk more about the corporate governance project, but one thing the ALI does, which is very shrewd, when something that was originally proposed as a prospective restatement ends up being so controversial that the membership doesn't seem to be able to agree on it, then you call it principles, and you don't have to worry about that overt controversy. But I think it's a challenge at this point for the ALI to think about whether you can retain the sort of traditional restatement format in the face of what I think is a altered institutional culture. So I'll stop there. Thank you.
Thanks, Ted. Deborah DeMott.
Thank you. Thank you, Bob, and thank you, Andrew, for everything, for bringing this to fruition. So I'll begin by discussing why my chapter has the specific focus that it does. Then I'll turn to the ALI's emergence as an ongoing institution capable of sustained existence beyond the first restatement project through the 1920s up into the early 1940s. So the title for my chapter is Restating the Law in the Shadow of Codes. You might wonder. When I began working on the restatement third of agency in the mid-90s, I was aware that in 7 states in the United States, most notably California, there were civil codes, and civil codes that codified private law subjects, including agency, dating from the last quarter of the 19th century and onward. I became curious when I saw that neither the first restatement nor the second restatement of agency mentioned the codifications, because I was also aware that some provisions in the California Civil Code are very different from the common law agency doctrines that are relevant and require different things. But I was also aware that the underlying stated commitment of the restatement, in particular the first restatement, was to, quote, restate the law as we find it. Now, that might mean there was a special definition of the law doing the work, or maybe where we were looking for what we would find needed to be looked at pretty carefully. Thus, my chapter then explores a paradox of sorts, one of several. So it's this: if part of the original motivation for the ALI, and particularly the first restatement project, was to ward off legislative codification of private law or the common law, to the extent of ignoring the existing codifications and civil codes, it's pretty remarkable that by 1942, the ALI became an enthusiastic participant in a project to codify a large swath of the private law through the Uniform Commercial Code. Looking inside the organization, or the ALI, as it evolved through surviving internal records, beginning with 23 years of minutes from the Council and the Executive Committee, another focal point for my work soon emerged. This is how, in the 1930s through into the early 40s, the ALI evolved from a single project organization funded, as Ted said, by one grant, one grantor, i.e. the Carnegie Corporation of New York, into an institution, one with potentially at least a fairly broad mission, as the vocabulary was, quote, an agenda of matters of the first importance, plus, and I'll say more about this, the financial stability on its own to complete the original restatement and to continue onward. The history that emerges is messier than one might assume, let me just say, based on today's ALI. Many more details in my chapter. Looking back, those who shaped the ALI's early history were working in a very different world, but they combined a tendency towards over-optimism, which led them substantially to underestimate the cost and the time required to execute major portions of the restatements. But they combined this tendency with the capacity for resourceful adaptation when circumstances changed of all sorts, which they often did. There were setbacks of all sorts, one of which Ted mentioned, the initial treatise commitment. There were interim deaths of reporters. There were other kinds of setbacks and unfortunate developments, but surprisingly, the organization, or maybe not so surprisingly, the organization proved to be very agile in adapting to the circumstances in which it found itself at any one particular time. I'll focus first on the restatement's form and format and changes, then the financial side of the ALI during this era. If you happen to have the book with you, and if not, as an enticement to you to acquire a copy very soon, I suggest that you begin with the illustrations, which are a set of photographic plates in roughly about the middle of the book, and I will say a bit now about two of them, beginning with plate Roman number 4. In it, Samuel Williston, who looms large in this early history, is photographed. Sam Williston, of course, became the reporter already mentioned for the first restatement of contracts published in 1932. He's standing beside 4 ginormous stacks of paper on a desk. They are so tall that in the photograph, it looks to me like they're tethered with string over top so that they'll stay on the desk. These comprised the draft and the manuscript for his treatise on contracts, which was published to great acclaim in 1920. The stacks of paper peak at about the level of Williston's shoulders. Now, plate 4 that I have just been describing, for starters, speaks to the challenges of legal scholarship and the work that scholars did in the era that Ted began with, and certainly for Williston. It may also explain why, with exceptions like Williston's treatise, most of that era's treatise scholarship about the law consisted mostly of little snippet summaries of cases with citations that were sold into a market of practicing lawyers who were always seeking shortcuts to citations. The plan for the restatement, though, was that it would include scholarly, clearly written, doctrinal explication, organized analytically, just like Williston's treatise, okay? And also, maybe we could say borrow a bit from the form of civil codes, beginning with a black letter, an extremely concise statement of authoritative rules. As Ted discussed, the original plan was that each reporter, in addition to doing the restatement drafts and defending them before the annual meeting, would also write a treatise, and ALI would publish the treatises. This plan was abandoned by 1925. In the council minutes, it's abandoned at the same meeting in which it is noted several of the reporters are already over the age of 65. And it's important, it's more important to get the restatements themselves done. Also, some reporters were not cooperative. Williston, very much an institutional citizen, I think probably would have been. Meacham never cooperated, in part because he had published the second edition of his comprehensive treatise on agency in 1914. There's not a lot of acoustic space between his restatement drafts and the treatise, and so what would be the point? As Ted said, it was also believed that there would not have been a market for the treatises, right, at the end when they were completed, either, I think, within the ALI membership or the profession more generally. But as I'll suggest shortly, I think that was very mistaken, as later events pretty soon start to demonstrate. As now, reporters' work involved extensive collaboration with advisors. Now a little vignette. Much work occurred over the summers. The groups housed for roughly 1 week at a time per project at William Draper Lewis's summer house in Northeast Harbor, Maine. Plate 6 in the book is a great photo. It's from 1937, the group working on the security restatement. It says a lot about how the participants in this project took their work so professionally and so seriously. In the photo, there are 5 men. They're standing in a circle. They appear to be having a conversation. They are so formally dressed. Each man either has a hat on his head or he's holding a hat in his hand. They're cutting a proper professional figure, notwithstanding the locale. Now, I'd also observe that they might also be grateful to be in Maine in the summertime, not, for example, working in New York, Philadelphia, or DC in the summer in a world in which widespread air conditioning had not yet arrived. Think about it. None of this, of course, came for free. Reporters were paid, as were the ERA's advisors. And given delays in the length of some projects, money started running short, certainly by the end of the 1920s. As Ted said, work on the first restatement was funded by a series of grants from the Carnegie Corporation of New York, overall in an amount of roughly $43 million in today's dollars. The minutes reveal delicate episodes in ALI's relationship with Carnegie, as understandably the foundation became concerned about how long the work was taking, almost twice the original estimate of time, and how much it was costing. To be sure, contracts in 1932 and agency in 1933 were completed pretty much on schedule and sold well. I'll say more about the sales structure in a moment. But financial storm clouds clearly loomed on the horizon, and a even larger question, what would the ALI do when the restatement was completed? More subjects to be restated? There was a list developed. Other types of projects, perhaps. Okay, so we'd say a storm cloud about the future program. I turn now to the implications of a development that short-term was a source of financial strain on ALI, but longer-term proved helpful. But like everything, things did not go according to plan. By 1927, aware of the interests of and commitments of commercial publishers, William Draper Lewis, this was after the treatise commitment had been abandoned, William Draper Lewis acknowledged to the council that, quote, somebody is going to get out annotations to these restatements, that is to say, annotations linking restatement sections with prior cases in particular states. This is bound to come, said Lewis. But commercial publishers were not necessarily enlisted in the project of simplifying and clarifying the law, okay, as opposed to multiplying citations. Carnegie mostly, not entirely, but mostly declined additional funding for an annotations project. Ever resourceful, the ALI turned to state bar associations to organize help from lawyers who would draft summaries of cases applying common law doctrines keyed to restatement sections. In the assessment of Herbert Goodrich, who did later become the ALI's director, and by this point was William Draper Lewis's, the director's second in command, this was drudgery, sheer drudgery. When he reports on the restatements projects, he often uses the term drudgery to describe the work required, but the work also had to be good and had to be accurate and reliable. ALI published annotations, volumes, pamphlets for several states, but this was, again, expensive, okay? The annotations, I think, helped allay concerns as to whether the restatement was authoritative and could reasonably be relied on by lawyers and judges. It also helped greatly with the sales of volumes of the restatements themselves. Okay, so for agency and contracts, many, many more copies of the restatement were sold into states where there were available annotations, which typically appeared at least a couple of years after the publication of the restatement volume itself. And Williston, Samuel Williston, contracts completed, soldiered on to edit these. That's kind of drudgery, maybe on a kind of meta level, you know, that he undertook. But the annotations made the restatement venture overall a publishing problem in Goodrich's assessment. By that point, ALI had entered into a joint venture with two commercial publishers, the West Publishing Company and the Lawyers Co-op Publishing Company, to create a separate publishing joint venture, American Law Institute Publishers, or ALIP, A-L-I-P, because the costs of continuing to produce the restatements plus producing the annotations overran available revenues. Okay? But wonderfully, the organization and those in charge of ALI adapted. They realized by this point, this was into the 1930s, that it might be possible to interest New Deal relief agencies as potential funders for state annotation projects. Minnesota, for example, the Minnesota affiliate of the CWA, the Civil Works Administration, funded an annotations project, okay, that employed impoverished lawyers in Minnesota. In 1934, according to the minutes, Director Lewis, and second-in-command Goodrich took a train trip from Philadelphia to Washington, D.C. to meet with the administrator of the Civil Works Administration, the CWA, and perhaps his counterparts in other relief agencies to urge expansion of the Minnesota Initiative. Okay? But over time, two things happened. First, the restatement finally came to be profitable on a very simple basis. By 1944, enough books overall had been sold that ALIP was able to make a $10,000 profit distribution of ALI's share out of sales, profitable sales made by that point. And of course, this was just in time, because the entry of the United States into World War II then basically eliminated the labor pool for the restatements projects, as more lawyers, particularly younger lawyers, enlisted in the military, and their more senior lawyers found work with war-related agencies. I'll return finally to a further dimension of the ALI's complex relationship, and there were so many delicate episodes in the history, with the Carnegie Corporation of New York, in the general theme of the ALI evolving into an ongoing institution. A good steward of the funds and the use made of its funds, Carnegie exercised active oversight over the ALI. It directed an inquiry in 1930, as early as 1930, into whether the ALI could be operated more efficiently, and in 1933 asked whether the salaries paid to reporters could be reduced. No, replied the executive committee in a very firmly written letter by that era's president, George Wharton Pepper. President Pepper observed that it might have been at the very start that the salaries paid to reporters were overgenerous, but now, when the push was on to get the work done, to get the final volumes out on schedule every year, to reduce the salaries threatened dampening enthusiasm for the work at its most crucial moment. But of enduring significance, I think this is underappreciated for the ALI, the last grant that Carnegie made was in 1940, when ALI's funds were very low indeed. This secured funding for ongoing operations as a going concern, and it enabled the completion of the restatement, the first restatement of judgments. Carnegie conditioned this final grant on the ALI's securing funding from its membership through fundraising from the membership and through dues. So by 1941, the ALI began charging dues to its members in the amount of $10 a year. But by then also, into the 1940s, the question about how to populate the agenda for this emerging institution kind of developed an answer. The answer came in 1941, I think, or maybe even earlier, maybe even in 1940, when ALI's leadership became aware of the interest of what I think of as the commissioners on uniform state laws in enlisting ALI's participation in an already begun project to redo and replace the not-so-successful Uniform Sales Act. ALI's counsel embraced the opportunity over the written opposition in 1941 of, yes, Samuel Williston, but moved on in 1942, formally to adopt the project and at the very same meeting, elect its reporter, Carl Llewellyn, to ALI membership. In conclusion, what emerges then is a sort of irregular, messy story of resilience in light of contingencies of all sorts. I've just skimmed the surface. The story is a messier one, I think, than assumed, but one in which the restatements and the ALI were very much works in progress in a very different world. Thank you.
Thank you, Bob. So first I want to thank Bob and Andrew and also the other contributors to this volume. I'm not a historian by training, and I have learned more about this, this body and what we've been up to through my colleagues. Even as comments were being made, I was taking notes as usual. I would also recommend to all of you, in addition to the book, we have an amazing archive of our history. If you look at our records, which are excellent and are largely available through Hein online, you'll discover sort of the seriousness and the commitment of the individuals who came before us, and really makes me quite honored to be sitting here in front of all of you. So with no further ado, let me get to my paper, or my chapter, which is on the restatements of contracts. And I'll begin by first describing what's not in this chapter, and it's a big omission. There is no mention, or in any significant way, of the restatement second of contracts. The Uniform Commercial Code is unfortunately not seriously engaged in with this piece. The restatements of consumer contracts is also not in this chapter. You should know I did try to sneak it in, but through prudence and Bob and Andrew encouraged me to limit my already too lengthy discussion. It turns out that there is enough to say, just beginning at the historical moment on the first restatements of contracts. And that's what that's my main project. The title of, or the subtitle, I should say, of my chapter, which I owe to David Sape for making clear to me after he gave me a number of generous comments on the chapter, is Reliance on the Restatements and Reliance in the Restatements. And I want to clarify what I mean by both of those and summarize somewhat briefly the chapter. First, the idea of reliance on the restatements. In some sense, the chapter makes an argument about the restatements, and I am limiting my comments principally to the first restatements of contracts as opposed to the other restatements projects, either in the first or subsequent waves, as a canonical document. And I mean canonical in the explicit way, as a document that users use as a point of reference, as an argument, and why it evolved and came about to be canonical is something that and even what it means to be a restatement is something that I learned by looking carefully, in particular at Corbin's discussion of what restatements is. I'll mention first that when one of the early, maybe the most critical review of the first restatements of contracts came from Charles Clark, then Yale, of the Dean of the Yale Law School, who described the restatements as delusive simplification. Dean Clark was also on the first restatements of property, which had not yet been published, and he went on in quite a sort of unrestrained fashion, describing the restatements, the resulting statement of the law. The resulting statement is nowhere the law, and its unreality only deludes and misleads. Now, part of this statement was true. It was half true. The restatement the gathered statements in the first restatements were nowhere the law. But it didn't necessarily delude or mislead. There was some suggestion that the restators were after sort of the hidden true restatement of the law. Neither Corbin, Williston, or any other of the associate reporters believed that there was some hidden and true statement of law. What they were aiming to produce was a restatement. And by identifying and restating a single law, their principal aim was to put forth something to deal with the complexity and the uncertainty which was prevalent at the time. As Ted has already mentioned, there was this kind of paradox, this notion at this moment in the early 20s as the Restatements Project is coming into place about the great uncertainty and complexity of law. And the paradox had this dual component. On the one hand, there was so much variability that we needed a restatement. And simultaneously, there was so much uniformity in the law that a restatement identifying how all the law is connected was possible. For Corbin, the solution to this dual problem of variability and uncertainty in the law really resided in the complexity that he observed. As there were storehouses, he described, of cases being produced and more statements, in all of that complexity, what he saw was data, lots and lots of data. This morning, Brad Smith asked the question, why does the ALI still need to exist today? Do we still need, will we still need a restatement? And he said, yes, we will. But this is exactly the way that Corbin saw the problem with all of the new data the reporters were putting to place. They were going through and able to identify, because of the voluminous cases, the possibility of a uniformed restatement. So for Corbin, I'll just say a little bit about his particular approach to restatements. Here's a quote from him relating the restatements of law to restatements in the physical sciences. The stated laws of physics and chemistry have to be continually restated in light of wider observations and more nearly correct analysis. It is in the same way and for the same reason that we have a continuous series of restatements of the common law, from the earliest times to which we have written down to the present. So for him, the restatements of the common law is not a product, but a process, a continual process of discovery and reiteration. That was the principal aim and product of the restatement. Now, of course, as Deborah mentioned, the Restatements Project always took place in the context and in the shadow of codes. And there was great worry, again, coming from Dean Clark, but from many others, that the restatements would take away, I'll quote him, stating the law as an existing thing invariably takes away life and vitality from the statement. That by fixing the law, the flexibility and adaptability of the restatements would lose its ultimate and useful function. When Benjamin Cardozo was charging the committee with going forward with its restatements project, he thought that he too, and no one, I should mention, wanted the restatements to be a code. No one wanted the restatements to be a statute. He thought the possibility of the restatements might actually be able to solve the eternal problem of coming up with a statement of the law but not at the same time fixing it. Whether or not that was achieved, it remains debated, but the aim always from the beginning was to characterize a statement on which lawyers, not legislatures, lawyers and judges would engage with the stated law, but continually restate the law. And so in the first part of my chapter, I describe how this is the way in which the restatements of law is canonical. It was never meant, and Corbin also emphasized this, it was never meant to be something that one would rely on as a final statement. It was always meant to be restated. And in fact, at one point, after Bob Browker was nominated to be the reporter for the second restatements of contracts, he approached then President Goodrich and offered him volumes of restatements that he had been collecting of the law of contracts over the past 40 years. He described it as a one-man version of the restatements. The restatements is a process for him. It's a process, and having the printed restatements was the point of departure, not the end of the restatements. So if that's what restatements, if that's what relying on the restatements means, I want to say a little bit about the second part, what it means that there is reliance within the restatements. Undoubtedly, the most controversial element of the first restatements of contracts is the notion of promissory estoppel. When I first started this project, I read literally every article, and there have been a significant number of articles from its inception to the present about promissory estoppel. It was highly controversial. I should mention that Samuel Williston probably gets more blame as well as more credit for promissory estoppel than he deserves. In fact, promissory estoppel had been batted around explicitly before Williston's first treatise on contracts, although Williston did prominently bring it forth. Corbin, through the AALS, at the annual meetings in 1916, actually had a panel discussion on entitled "Promissory Estoppel as a Substitute for Consideration." Now, you all remember from your time in law school that Corbin and Williston are often presented as the odd couple, always on other competing sides of many important issues. But on one point, they were really well aligned. They were both in full agreement that reliance was the historical and traditional basis for enforcement of promises, not consideration, the more bargained for or more novel bargain for consideration doctrine. While they both agreed to that, it's true that Williston had somewhat abandoned and looked to move away from reliance in favor of the bargain for consideration argument, first promoted by Langdell and Holmes, and by him significantly. But he never lost sight of the historical grounding of consideration. And some of this is this history is captured in Grant Gilmore's wonderful book, The Death of Contract. But there is a lot that's not stated in that book. And Barbara Black has done a tremendous amount of work looking at, in an unpublished chapter called Williston and Reliance at the ALI. And Barbara shows, I think in quite persuasive ways, that Corbin and Williston really were working a way of reintroducing reliance back into the restatements of contract and making it more fundamental, while at the same time putting forth I would say, a canonical version also of the bargain for theory of reliance. And there's a way that one can see how restatement then, this bargain for theory of reliance, Section 75, then Section 75, and first Section 88, and ultimately Section 90, these two kind of restated versions of what the law of contracts is at the time, I think set the pace and the agenda for the development not only of in significant ways, the legal realist reaction to it, which is something that Bob describes in his chapter, but also influence Llewellyn, the Uniform Commercial Code, and the second restatements of contracts. Interestingly, they were both worried that if the American Law Institute were to make a statement, giving a formal statement recognizing reliance as the explicit basis for enforcement of contracts, that judges would feel too much license to enforce contracts without consideration. So in order to avoid that risk, they placed on constraints on the restatements, Section 90 of promissory estoppel, that actually didn't exist in the common law. The ultimate statement of Section 90 completely underlies the true form in which estoppel and reliance on promises were enforced. And this is something that Llewellyn discusses, that everyone sort of recognized at the time. It's somewhat ironic that in order to create this distinct doctrine of promissory estoppel and reliance, they actually had to trim it back in an interesting and unfortunate way, in a way that, following Learned Hand's opinion in Gimbel Brothers, maybe the first prominent promissory estoppel case after the restatements first was published, both Corbin and Williston made a concerted effort to liberalize reliance. I'm going to wrap up by just mentioning very briefly that if you search the first restatements, if you search the second restatements, you will find a document replete with reliance as a justification for the enforcement of contracts. It runs throughout the document. The great irony, in some sense, is not that Section 90 and promissory estoppel swamped out bargain for consideration in the way that Gilmore suggested it might have. In fact, it didn't do anything of the sort. What it did was to crowd out all the ways in which reliance as a basis for enforcement is codified, or I shouldn't say codified, is instantiated in the first restatements and subsequent restatements of contracts. Section 45, for instance, reliance on a unilateral offer is accepted in the first restatements without any debate. You'll all remember perhaps Maurice Wormser's famous hypothetical, said to be the most famous hypothetical, of offering someone $100 to walk across the Brooklyn Bridge and then retracting just before the final steps. That was a huge debate at the time in the burgeoning and just beginning law review articles in the American Academy. Williston was on one side, Corbin was on the other. By the time the first restatements was published, just 5 years later, no mention of it is there, none at all. Reliance remains this kind of, in some sense, Section 90, promissory estoppel, completely swamps the notion of reliance elsewhere in the document. So I'll stop there. Thanks, Bob.
Thank you. This is 500 pages of intellectual and institutional history about the collective deliberation to restate the law, write codes, write principles, and so forth. You might think that this is a material for a very dry report, but it's not. There are materials of high drama in this volume. Let me just briefly quote from you in the middle of the principles of the corporate governance project, about which there's a wonderful chapter in this book by Bill Breton of Penn. The director, Herbert Wexler, said, "This is the nadir in my long experience in this great organization, in which civilized discourse and reasoned dialogue have heretofore been the only weapons allowed or brought to bear. It is a frontal attack on the integrity and objectivity of our institute, and insofar as the conduct of lawyers is involved, a challenge to what I conceive to be the proper standards of the bar." But this was hardly the first or last great controversy in which the ALI was involved. There were all the legal realists attack, which were characteristically quite intemperate in tone. One of them suggesting that the work of the institute would be better occupied in doing surveys of lawyers about the proper state of the law, provoking really indignant response by Director Goodrich. There is the controversies over the sexual assault provisions, which I think many people in this room will probably remember. The controversies over aggregate litigation, controversies over family dissolution, there's that great debate about the death penalty in the model penal code. All of the great struggles of law in life are in one way or another kind of reflected and replicated in the arguments of the institute. And one of the great achievements in a way of the institute has been to bring these enormous materials of social controversy and political conflict into the confines of reasoned and for the most part, extremely civil discussion and deliberation. And so the institute's lasted for 100 years, which is kind of a long run for a law reform venture. In fact, it's hard to think of any law reform initiative which has this kind of lifespan. And of course, it's flourishing. It shows no signs of being extinguished soon. So in another 100 years, we'll have another meeting and another volume. I hope to be there.